of the ruling the court delivered.
Your Honor, fortunately these proceedings are being recorded by the system.
Yes.
And all media houses.
And all media houses. Your Honor, the court is now the accused person.
Yes.
Now, being the accused person, the only way, Your Honor.
Did I make a determination anyway?
That is what I'm wondering, my lady, Your Honor. I'm really wondering.
Your Honor, don't ask the state whether you made a determination.
Your Honor,
just record our
I
submissions.
think the best way we can proceed with this issue, instead of getting sentiments, allegations, I don't know what else from the back, we'd like a formal application to be made with an affidavit signed.
It has started.
That is what we'd like, my lady, because even
It still
after
goes
all
to the
this
question,
goes through,
if
we
this
will
court
ask for a
controlled by the
notice.
DPP, kindly take charge of the proceedings and leave the DPP.
And we're threatening the court.
Your Honor, they cannot allege that we are controlling the court while they are threatening the court.
No threat, Your Honor. No one has threatened this court. No one has threatened the court. Your Honor, I was on my feet. Maybe Koram could indicate that my senior Apolomboya is now present.
Sit when senior stop as to.
And that is a senior counsel, Your Honor.
No, sit. I'm your senior.
Senior counsel.
Just sit.
Your Honor, I'm on my feet, Your Honor.
Yes. Yes, sorry.
I'm on my feet, Your Honor. Apolomboya has just come in
Let him say.
and found the proceedings ongoing. And I was making a submission, Your Honor.
Your Honor,
Can
I
Your
think
Honor-
decorum in court, and this one I'm talking about, we have to address the court with some dignity.
As a judicial officer, I have endeavored to uphold my oath of office and most specifically to do justice in accordance with the Constitution and by the law established and the laws and customs of the Republic without any fear, favor, bias, affection, ill will, prejudice, or any political, religious, or other influence. And to do so, I also do so in ensuring that it is respective of the people who came before me, irrespective of their age, gender, nationality, color, religious affiliations, or creed. It is strange to me that the applicant will forum shop and file the application before this court. The question I ask, for what aim? I disagree with the first respondent that forum shopping played part in the application, in the filing of the application before this court, and unless the first respondent has something that this court has no knowledge of. And in the upshot, my finding is that the application by the respondents that this court lacks requisite territorial jurisdiction to entertain the application lacks merit, and the same is dismissed.
Most obliged.
You know, we are much grateful for the reasoned ruling. We have instructions to seek for the type proceedings and ruling. Taking cue from the sentiments of the court that there exists a legal lacuna on where this new animal called the miscellaneous application Parliament has not been able to legislate. And had this been a high court, the court could have issued directions to the Attorney General within set timelines to initiate legislation on this matter. nationally miscellaneous applications being filed in this country are in hundreds of thousands. We shall be moving to the High Court.
No, I'm sorry, I really need to interrupt. I believe you're seeking the typed rulings in this matter, and that is where
I'm proceeding to lay. I'm laying the basis. I don't know what the state is panicking about.
You're not panicking. You're saying that you've asked for a copy of the ruling.
I'm moving
That should be the
ahead.
issue.
Kindly, Your Honor.
You can ask for more things.
The state cannot tell us what we are asking. They can only oppose on what we are asking. But we have a right to ask. Your Honor, 2, we shall be moving to the High Court to settle that question of law. For the country to know processes on the question of miscellaneous application. And that is what I was laying. I don't know what the state is worried about. We shall put the state as a respondent in that matter. So don't worry, you'll be there, plus the DCI. This is for the good order of the criminal justice system. It's not the good order for the first respondent. You know, that role could have been done by the good officer of the ODPP. But having abdicated their role.
My lady, again, these are issues that he can put in the application to the High Court. He's made a request. I think we can cater for that.
Same the court style.
Your Honor, may you allow us that precious opportunity, and that honor shall be that your insightful admission of lack of the law be settled once and for all. Unless my brothers are completely. That's all. They can now respond.
So that we can move
Let
to
us
the
respond.
next.
Does the court intend to make a ruling on the request to supplement?
General application.
Then we have
Yeah,
no problem with the
According to
ruling.
me, what was coming before the court today was on whether it was
As you are satisfied with the court, yeah.
we move on.
Yes, ma'am.
Moral.
We are ready to move on to the next level. So, even when our assessments are been directed by the court.
Office of Proceedings. Will be certified as requested. Upon payment of 36 times.
Much more. Much.
Now, the person you're saying did not get a day has been forced. I've seen an application for and now
We have not seen
You
it.
have not seen it. You have not been served with it.
yes,
Neither have we
the
seen
file
the
is
person.
now in growth. And from my scanning of the application, the DCI through the OTPP, they seem to be, the application is almost pretty the same as so that we can can decide what to do. Both persons proceeding.
You're not even
There is
as
minimal
the
addition, because if you say we have one part and we start the other one all over, we may take the whole bill.
Could that respondent then be arraigned in court? So that
we agree, because when I look at that application,
You know,
because of the background,
You know, we are saying, as you are looking at that application, it will be fair that the person being mentioned be in court.
when I look at the background information for him being arraigned, that background seems to be the same.
You know what we are saying?
With the
That those directions, let them come from you when he's around.
What we do, he's not here.
He's not there.
My lady.
That's what I'm saying.
My lady.
Yes.
I'm so sorry to interrupt. Yes, that is what we would have preferred, Your Honor. Because yes, so we can proceed with these ones. We finalize. With the rest, we'll be very quick about it.
It's a separate file.
It's a separate file, my lady.
I hold a different view. We are discussing on something that we have not laid our eyes on. So that instead of duplicating, because we've been using maybe the same authorities, and I believe they are seeking for orders, custodial orders, maybe, I don't know. Can we be supplied with that
If
application?
the applicant says that we do them separately, we can just have.
The court can even suo motu, deal and consolidate the
The
same
only
because
problem
the
is that
issues.
you don't have to also take proceedings in the two files. But I just wanted to see whether it's possible.
My lady,
The
Your
issues
Honor,
are
Before we even further
You
discuss
prefer
about this,
to do it
I'm on my feet.
separately?
I'm on my feet, I'm on my feet. As we deal and deliberate on these issues, let the person that we're
Be in
discussing
court.
about be in court.
the file I have, the one I have is for this.
yes.
This one I've not yet called it. I'm just saying I have seen it. I have seen it, and I see it's almost the same background. You can either agree to do separately.
Your Honor, on the
The
state
mover
side.
will tell us. We are the movers.
Yes, my
We do
lady.
them separately.
Yes, we would prefer to do them separately. If you give us time allocation and guidance, we'll be able to move as quickly as possible.
Because what then we'll do, let then we
Maybe the exchange that we are having is only between the court and the prosecutor. You're discussing things that you have seen and they have filed.
And the person
We are supposed to keep quiet and listen.
You see now they are the movers.
Yes. But let them discuss it with our person here.
Let the person be present.
And they know the
discuss.
applications. They
Your
can't
Honor,
discuss all the
They
Your
can't
time.
Honor,
discuss
we are
without
here
the
for
person
a
being
specific
present.
matter. And we have
Then why
just
are you
had a
discussing
ruling
this
of
other thing?
jurisdiction on the matter. We'd like to proceed with that matter first and then proceed with any other application before the court after. There is no,
We have up to 5 p.m.
yes, we have ample time, my lady.
Let's just stick with us who had a date, then I'll give you that hours.
Could we be served with that application even as we deal so that we can...
Let's finish with this. Then I'll serve you, you take a break.
An application has been made, Yona, kindly.
You see, I'm not recording anything.
Yes, this is off record. This is off record. And these are ground rules that we are laying so that we also be good in saving on time. Let's kindly be served with that application. We look at it. Then maybe ask for us to make submissions in relation to the two applications, the one that was filed yesterday and one that is on today.
When we are submitting on this, don't talk about alone. And then once we get to him, we'll talk about.
May I kindly request this, Your Honor? May I kindly request this? We get served with that application. We take a break of 5 minutes. You allow us to make submissions on whether we can consolidate or whether
Your Honor, the application is for the state. They cannot consolidate for us. Yeah.
And you can't decide the cause of someone's matter.
But you are discussing it.
It is the court that opened the Pandora box to discuss it.
And now you jump.
And once the court has issued directions, we have no problem.
And probably that will also tell us that because yesterday, Oracle was not here, we didn't discuss it.
Yes, my lady.
So can we then desist discussing him here?
If Oroko is not mentioned
What we
anywhere,
do, now that yesterday we did talked about him and this application does not mention. It was not even very clear. So, can we not bring him here? Because now, then once we get to him,
This application does not mention a rock.
that we don't keep talking about the rock in this application.
Yes.
Yes. So we just deal with this file, finish with them, then once we get to a rock.
With humility to address an issue. Your Honor, indeed, I agree as much. The application that lies before court does not mention a rock. But one thing that is cross-cutting in this application and the one that we anticipate is the shooting or the assassination of the late MP of Kasapul. Your Honor, the question about consolidation of matters is one of law. And the court done so in an attempt to save on judicial time. So that, Your Honor, if you permit, it will be important that we are served with the application that we anticipate so that we can help you in saving of the court's time. It is not proper use of judicial time if we argue this application and then we take some time again and come and re-argue an application on almost similar facts. That is not proper use of judicial time.
I agree with that, it is proper use of the time, but from where you sit, you cannot consolidate someone.
We have not applied.
Your Honor, they are anticipating, and we are saying there is no prejudice that will be caused to Aroko because the application against Aroko is different from the one we had yesterday. So let them not anticipate what is in that application. They have time to defend their client. There is no prejudice that is going to be caused. The court is here up to 5 o'clock. The court will hear both parties. So let us proceed with this application.
Your Honor, I'm shocked. I'm shocked that the state will say our client cannot be prejudiced. The client has not hired the state to defend him. It is us. It is us who will identify the prejudice. So,
My lady, we are ready to begin.
Your Honor, we stand guided.
So that's, with a lot of respect for the counsel for the respondent, let you the respondent here, the fight.
Okay. Let us start.
Let us start. So that's where we're going to
My lady, do you have...
then,
Your Honor, in response to the application, of this bill, we have filed a reply affidavit. That's what the state is panicking over nothing.
No, we never panic. We have received the same, it has just been...
We have not put it on record.
We have mentioned
It is not yours,
So
it
I
is
am saying
ours.
that we already have
Let
it, my
us
lady.
put the house in order.
So the prosecution does that start, then you respond your final.
Yes, my lady.
So, Your Honor, hello?
Just a minute. You know what is CRA? It is that application, then you're saying you have filed an application, affidavit.
We have filed a replying affidavit on behalf of the first respondent, dated, it is dated the 8th day of May 2027, which we have served the state. It is dated 8th of May 2025. We don't know whether the state will be ready to proceed based on that affidavit. After that question, we have another preliminary issue to raise before the state starts making the application.
My lady, we have seen the said reply affidavit. We are ready to proceed.
said I have preliminary issue to raise before the state House Justice.
Okay.
Kindly. Your Honor, considering the ruling that you have made, we will be seeking 5 minutes break to take directions from our clients. So that we will be ready to either proceed or not proceed, considering the ruling that has been given. 5 minutes.
No objection.
No, the reply affidavit was there because of any other justification, but we need to be able to look at our client.
We take the instructions.
We have not spoken, as you can see in the document.
The ruling has just been made. The ruling has just been made. We need to take instructions from our client. That's all.
We don't have objection. We are most obliged.
Much obliged.
Your Honor, on behalf of the first respondent, we have instructions to make an application for recusal of the court on grounds that, one, the first respondent feels that the court is biased. And two, the court has handled matters where the subject matter is the assassination of the Member of Parliament for Kaspul, and the court has made a determination to detain the respondents in those matters for 30 days.
For your information, they never objected. The respondents never objected to that detention.
Your Honor, I make an application. The court either can respond. You allow me to make an application. Yes, I'm coming to that.
That application, in fact,
Your Honor, could that be the ruling?
In fact, the state was asking for 30 working days, which the respondents themselves agreed.
Your Honor, could that...
Court, just 1 minute, but as the court, not even as we submit, the state requested for 30 working days, which the respondents agreed, but even as the court diverted to 30 calendar days.
Could that be in the ruling as an answer to our application?
So the respondent. I just putting that in proper perspective because at least that one I have a knowledge of. Okay. No, I will come to you once he's through with the first respondent. I'll come to you. But I was just putting that in proper perspective that application was completely unapproved. We have to even reduce the time the respondent.
I wish we could have laid the basis.
Then we can proceed.
Let me proceed. Let me proceed so that the court can give a reasoned ruling on all the issues that we've raised.
Yes, proceed.
Kindly. So we were saying, Your Honor, that the court has already made a definite decision, and that mind is already set. Yet of great importance, there can never be two decisions from a same court where facts are the same, where the subject matter is the same, where the court making those is the same.
The court handling.
It will be fair that this matter, the court handling it now, recuses itself, and another judicial officer will have the time to exercise his or her mind independent of other decisions. Your Honor, this is the norm in all courts, where the courts say, I have already made up my mind in this matter. Let another judge, let another court also make a mind on its own. Your Honor, lastly, I've only laying the grounds, my colleagues will bring the facts and the law and the authorities on that. This court has denied the chance for our client, Mr. Oroko.
No,
you are not the one.
Again. No, the court has already made a decision on
I
that.
am not accusing the
Let's not
DP.
go to the issue of Aroko, please.
What I'm saying,
And the reason why I deliberately said the part for Aroko is so that you assist. Bring him here.
Your Honor,
Let's deal with this. If
Your Honor.
you need me to recuse myself in this,
it is one of the
once you go
reasons.
to the Aroko file, if you don't need to proceed this, okay. Council kindly let's not bring Aroko.
Your Honor, let us give our useless grounds. Dismiss them by law.
Because Aroko's file is
Yes, Your Honor,
What
you
I'm
already
saying-
made a decision on that.
Your Honor, what I'm saying,
Please don't take us the part of Aroko.
let me not make an
If you
application.
want to talk a whole day about Aroko, we will get to you.
Your Honor, let me not make an application that the state and the court are one and the same thing. This application is about recusal of a court. It is not
That
about
allegation is so grave.
recusal of the DPP.
That is an allegation that is so grave. The state is the state and the court is the court.
It is very simple, Your Honor, that for him to make an application, before he mentions the name Morocco, you do not know what he's going to say next. Why don't you allow him to say what he's going to say?
Dismiss it.
Ngoja.
The court had already
No,
made
no,
a
no.
decision
You-
on
you know
that.
what I'm going to say
Why are you
next?
bringing it up again?
Do you know what I'm going to
His
say
file
next?
is
I am
separate.
addressing the
It should
court
be dealt with
and I should not
separately.
be addressed by somebody from the side.
It should be dealt with separately.
Let him say what he wants to say. The moment he has said it and it is not in reason, you will ignore
You
it
dismiss
or you will deal with it in the application and say it is not relevant.
Your Honor,
Such that, Your
matter.
Honor, so that the prosecutor does not stand up and keep on making noise as I'm talking,
I'm not making noise.
you should
I'm saying
agree
we'd
that
like
if he's
it
making
in
an
written.
application,
We'd like a written formal application.
then allow us to do it. We'll still do it.
I'm dealing with miscellaneous criminal application number E081 of 2025. Can you restrict ourselves?
No, but Your Honor, wait, just let me say this. Your Honor, when we come to court in the morning, and when we reach here, we find that you have an application for Aroko. You're having the file. You start speaking about it. The prosecutor responds. The two of you just keep on conversing about it. You have been served. We are coming to this court about it, and we are not served. But you discuss and decide, can we consolidate, can we not consolidate, can the facts the same and all that. That means you have read it, we have not. And we are supposed to also, even for a moment, be told that this is what we are talking about, this is the application, so that we can also give a contribution. So the prosecution is telling you, no, let us have a different time, we can do it. The court is saying, no, the facts are same. Are we just coming to what? Isn't that bias? Isn't that
I think, I don't know whether we are seeing things from a different perspective.
Completely.
The reason why I mentioned file for Aroko is because I didn't want to be taken the part of Aroko today. Maybe I was taken the part of Aroko yesterday who was not before. So that we can distinguish issues and we deal with issues separately. That was my intention. So that once we get to Aroko, we deal with Aroko. Once we are dealing with this file, we deal with them. So that you not start telling me that Aroko has not been brought 24 hours have lapsed. So that issue, it's not subject of our discussion. The reason I brought the attention is, so anything to do with Aroko, let's not go to that deliberations because the family is here. So the issue of telling me now it's 24 hours have lapsed, it's not been brought, now I make a fighting on it. Those are the issues that I didn't want to. So what I'm saying, so can we just deal with E081 of 2025? Once we are done, because even the other respondents, they really want to put something. And I really want to hear them. I really want to hear Edwin or Joel, Dennis, Aaron, or what because I can see also listening. Can we deal with E081?
You know what we are requesting?
Yes.
At 157 does not give the DPP power to run this court. We are feeling, our client is feeling that the court is under the control of the state. And that's what we are praying, that we are making an application to you. Let the DPP keep off. Thank you.
The other respondents
allow us to say whatever we say.
But what I'm saying,
Your Honor, counsel can also raise in his application for recusal that he feels the court and the DPP are the same. He can raise that as a ground so that we proceed.
No, let's be professional. Let us be professional because we're the professionals here. Myself, DPP and the other. We're the professionals here. And let's carry ourselves the professionals that we have. And we know the proper thing, and we need to do the proper thing. Can we address the issues of E081 of 2025 in E081 of 2025? We exercise professionalism, all of us, myself, because we are the professionals. Once we deal with that, the court will make a decision, the other parties will respond, and then we deal with that. Once we get to E082, we will get there. And we deal with the issues of reconciliation. Let's be professional. So kindly, as much as it is so tempting to talk about so many things, let's restrict ourselves to E081. Sometimes it gets so exciting and want to talk about it. But let's narrow our issues.
Let's proceed.
Let's not get excited over anything else. We deal with one case so that the court can make decisions on the merits of each individual case. Because remember, at the end of the day, it is individual criminal culpability and responsibility, even if they are fighting.
Yona,
Yes,
allow me to proceed.
Yes,
the state should know that their removal is at the Public Service Commission. Let us deal with the question here of this court. Thank you, Your Honor. So it is our considered view that already the outcome of the number of days the state wants is already determined. our client feels this is a conveyor belt, and yet the decision is already clear. And that is why he has instructed his counsels that he is not comfortable. He has no problem this matter, his matter, being heard in a different court. On behalf of the counsels representing him, Your Honor, those are the sentiments of our client. As lawyers, we have no problem with this court, but our client has a problem in how this court has handled his matter. Your Honor, from the ruling, the court went to defend itself in person. It is not the court, the trial court, that was the question. It is JKRA Chief Magistrate's Court. But the matter was not brought to an individual judicial officer. The respondent was against this matter being heard by by JKIA courts, whether they are 10 or 20. In the ruling, the court has defended itself in person. In the ruling, the court has defended itself in person. And the tone of the ruling, the texture and the wordings of that ruling scare the first respondent. And that is why he say, allow him to appear in the ruling, because it has been said, and the court has said, any judicial officer in the country can deal with this matter.
That's why he's saying, allow him to appear.
He's fearing the tenor and the texture of the language.
I think that line was being mixed up a bit. That is why he's saying, allow him to appear
before any magistrate in this country other than this court. I said ground for my other colleagues too.
Matters that individuals or counsel appearing or parties moving the court must weigh against the possible outcome of that allegation for recusal.
can group matters that counsel appearing or
Must make a very deliberate decision after weighing on all the circumstances that are attendant to it. I say so because matters of bias now makes the court to be the accused entity. Because we will not ask the court to take the dock to express itself of the feelings and sentiments, and those feelings and sentiments will only be by way of a ruling that the court is going to render. In a nutshell, yes, on whatever that we are presenting on issues of bias, on the issues of recusal. And in so making the court to be an accused, we are seeking for the court to call itself to a meeting, examines itself in chief, cross-examines itself, re-examines itself, and makes a decision that may seem to be fair and not biased. Because we are talking of perceptions. And perceptions, when faced by human beings, including the court, really weigh down from individual to the other. And in this instance, the perception that the first respondent has against this particular court is a perception of it not being fair in the decisions that it's going to make, bearing in mind that there have been parties previously who appeared before this particular court, and there are more still to come over the very issue of investigation in relation to the murder of Sir Charles Webb. It then calls for moral authority from the court to weigh this heavy submission on recusal, so that you don your tools. You are not the only judicial officer in JKIA Chief Magistrates Court. And sit ground for another judicial officer to process the first respondent on account of bias from the Honorable Court. And there's an issue that makes us, or the first respondent gives us instructions to apply for recusal. There's a reason. The reason itself is and however much we would try to run away from it, it is still recur, is that this morning when the court rendered its decision, the ruling about jurisdiction, it brought to our attention of another file. And the sentiments by the court then were that that file is now before the court. It presents similar grounds as the one that we are currently dealing with. And the court was quick to say that the two can run together.
That was still in the ruling.
After the ruling, after you delivered the ruling.
And that was off record.
Off record,
That
yes.
was
Off record, off record, on record.
Also not record.
Off record, those are issues of perception. Presenting issues of
Perception.
No, my
Perception,
it was
madam.
not on record.
It is
It was
perception.
not on record.
It was not on record. It was not on record. But
Yes,
after listening to the
What
state,
we are talking of records cannot now be records.
Perception. Perceptions are everything, my
There
lady.
cannot be any perception when it's not on record.
directions. And also,
So, allow me to finish my point. Allow me, you'll have that time to defend yourself in your ruling. You have anything to do
You cannot
the
raise
defense.
things that are not on record.
Courts defend themselves in a ruling.
You cannot raise
Kindly allow me to finish. Allow me to finish. And arising out of that pronouncement, which was again reneged on immediately after the state indicated that the two files should run separately, our client had this perception. He was reasonably apprehensive that this court is not going to give him justice. And that we wish it to go down on record.
to conceptualize that.
I repeat again,
No, I'm trying to conceptualize that. Because I don't know how fast...
those are the apprehensions. Those are the apprehensions.
I'm talking of the rulings that court delivered.
Your Honor, fortunately these proceedings are being recorded by the system.
Yes.
And all media houses.
And all media houses. Your Honor, the court is now the accused person. Now, being the accused person, the only way, Your Honor,
Did I make a determination anywhere?
That is what I'm wondering, my lady, Your Honor. I'm really wondering.
Your Honor, don't ask the state whether you made a
in fact,
determination.
Your Honor,
Just record our
I think the
submissions.
best way we can proceed with this issue, instead of getting sentiments, allegations, I don't know what else from the back, we'd like a formal application to be made with an affidavit signed.
It has started.
That is what we'd like, my lady, because even
It still
after
goes
all
to
this
the
goes
question,
through,
if
we
this
will
court
ask for a
controlled by the
notice.
DPP, kindly take charge of the proceedings and leave the DPP.
And we're threatening the court of
Your Honor, they cannot allege that we are controlling the court while they are threatening the court.
no threat, Your Honor. No one has threatened this court. No one has threatened the court. Your Honor, I was on my feet. Maybe Koram could indicate that my senior Apolomboya is now present.
Sit when senior is stop as to
Unless it's a senior counsel, Your Honor.
No,
That is
sit. I'm your senior.
Senior counsel.
Just sit. A little bit.
Your Honor, I'm on my feet, Your Honor.
Yes. Yes, sorry.
I'm on my feet, Your Honor. Apolomboya has just come in
Let him say
and found the proceedings ongoing. And I was making a submission, Your Honor.
Your Honor,
Can
I
Your
think
Honor,
decorum in court, and this one I'm talking about, we have to address the court with some dignity. Okay? You cannot attack a judicial officer from the bar without making a formal application, putting an affidavit, indicating the reasons why a judicial
Objection, Your
officer...
Honor. Objection, Your Honor.
I'm still on my feet.
You just will come
You
out.
just
and-
want-
I'm
Objection.
still on my feet.
Objection, Your Honor.
Didn't you find him on his feet?
You know what? I've been a CEO of the Law Society of Kenya.
Your Honor, let's
And there are certain behaviors.
it was
That-
failure that removed
that-
you from there. Don't tell us.
It's not walking in.
Yes.
And Your Honor, some of the councils have actually been misconducting themselves by even making certain allegations to the media,
Just a minute.
including yesterday.
Just a minute.
which we shall also bring to the attention of this court.
Just a minute, Council.
Yes,
All I was
thank
saying is that I'm acknowledging on record you are working because I noted that when you read the ruling on whether the court has jurisdiction, you are absent. So the record shows now you are coming.
Thank you.
But
Most obliged.
can we deal with what the court has made a ruling on? Even as you made, I never made any ruling, I never made any directions, and it was just a request. Whether the two parts can be heard, and then also to notify the respondent side that kindly don't take me the route of Morocco because we deal with you. So I don't think I made any directions anywhere. So I don't know why you still want, you really didn't want to bring Morocco. Why? Why do you want to bring Morocco?
the issue.
The council for the past respondent, just concentrate on your crime.
The issue.
Leave Morocco out of this. Because I think you really want to force Morocco here.
We are not forcing Morocco. We are not forcing Morocco, Your Honor. All we are saying,
and I don't know the nexus between the first respondent in Morocco. When the details we deal with him, then after that,
we are dealing,
Morocco, we deal with Morocco.
Your Honor, we are dealing with the file that is before you. And the file that is before you has nexus to a file that is, again, going to come before you or any other officer. And that is the issue that we are saying of perceptions. And perceptions are very, very heavy to deal with, so that then the next question we'll ask, or the first respondent is asking, whether this court is going to be impartial in the decision that is going to render after all this has come to bear. And you know, it being that this is not a court that is run by a sole judicial officer. There is another court. You have two courts here. Even when we are making this application, which has got no feet to stand on, kindly accord us latitude that we go before another judicial officer, that we will feel that is not biased, and ventilate our issues there, where we will be discussing about the issue whether or not 30 working days should be granted for the first respondent to be held as they do the investigation. Because if again, as you do that examination, cross-examination, and internalize what we are saying, if the court again says there is no element of bias, that bias has, in the perception, in the mind of the first respondent, is there. So, however nice the ruling is going to be, or even 10 days, 2 days, 5 days, that will also not sit well with the first respondent. So kindly allow us to go to another judicial officer, we process our issues there. Mr. Beta will add one or two issues.
Yeah, Your Honor. Let me maybe speak in a very simple, maybe clear way, because of the issues that will be addressed in applications, either past, present, or the ones that might come if any other arrests are made. The person that we are talking about as a victim is the deceased. He is the common person in all these applications and the future ones, and the present one, and the past one. The officers conducting these investigations are still the same officers. So they make affidavits through the state that have similar facts. And asking...
On the accuser.
Yes? No.
Still addressing court on the accuser.
Yes, it's coming. That's where I'm coming to.
For me, let's go straight to the...
No, Your Honor, because this is the background I'm building so that you can understand me. If they are bringing the similar facts on the same issues, the only people who are different players would be the suspects who are being brought to court. Those are the only different persons. and maybe the council. The court has made previous decision on this matter. Made a previous decision on this matter. And this is where even natural bias then will come in. Having made such decision in such a matter that has similar facts, does this seem like the court will make a different decision? Is it possible that the court can make a different position? I am what you call a reasonable person, or a fair-minded person, or an observer. Same with the first respondent. The first respondent has knowledge of what has been, what the decisions have been. The court definitely will not shift from that decision. So what is the problem here then? This court, knowing that these are the files coming to it and has made a decision on one, why can't it allow somebody else to make a decision on any other court to make a different decision, if at all they can? Because you will not change, and therefore all the other applications that are coming is just a mere process. If the same person appears as an accused person, I'm imagining here, and is charged in different files, will the court still handle that person? In other cases, no, you'll always say, this person has a case before me, peleka kwa koti ingine. So simply, let's turn the tables. The facts, the people who are coming, the applications which are coming are the same. Give somebody else to make a chance, because natural bias is going to come in. Have the courage, the power, the ability to walk away from these other applications. That is nothing wrong with that. In fact, that is integrity. There is nothing wrong with that. It shows courage. Because right now, when we are saying, and this is what Mr. Omari was saying, the issue of JKIA, we are not saying that you have never even appeared before you before. I have never. So I have no reason at all to say anything wrong about you. Nothing. But if the client says that he has this feeling and there is an apprehension, I will not keep quiet because I want to oil you. I will say what my client has said because that's what he wants. So, does he want to feel free and know that his matter is being addressed well? Yes, that's what he wants. But he's saying he does not feel that this freedom is going to be there if you still keep on handling these files. Because we can predetermine, we can see the decision that is coming at the end of the day. Walk away from this.
The TV, the cameras are running. You must understand. I'm sorry, but my senior knows it better than I do that the Supreme Court is the apex court in the Republic of Kenya. Thank you. Yes. Your Honor, the Supreme Court dealt extensively on what we make thank you, Your Honor. Your Honor, the very last decision I will wish to make reference to is that of the Court of Appeal. In the decision of Philip Tunoi, retired Justice of the Supreme Court, of the Court of Appeal, sorry. Justice Philip Tunoi versus the JSC and another. No, Your Honor. Yes. We are very familiar with these people. Versus the Judicial Service Commission and another.
Thank you
citation.
We shall be looking for it. The research team.
Yes, Your Honor, Thank you. Your Honor, as I yield ground to my colleague who might have one or two words to say, permit me to urge you most respectfully. Your Honor, let us help these wheels of justice in grinding quickly. You have the power and the authority of summarily allowing our application and allowing us to be heard in the next 2 or 3 minutes before another judicial officer so that we can determine these issues, Your Honor. We are most obliged. Thank you.
The citation.
Yes. Your Honor, the citation where you left the gap. Your Honor, it's 2016 EKLR.
The new case or something. Have you opened the new? Shall we agree case or something?
Yes, this is KESA 530. 530.
This one is what for photography.
Yes.
Did you put something for just and there? So the case
No.
of 530 is under photography.
Yes, the question on recusal never went to the Supreme Court, Your Honor. Thank you. Largely because usually it's a question of the court's discretion. It's you feeling inside you that you might not be fair, that the court, there's the perception of it all. Thank you.
Yes, you understand it, Manju. Your Honor, I do not wish to belabor much on what has already been said, what has already been submitted on. But mine, Your Honor, is to simply state and humbly submit that this issue of disqualification and recusal has two playing factors, Your Honor. Yes. One is that it is very intricate. And two, extremely delicate, Your Honor. And the intricacy of these kind of applications, Your Honor, is that the application fashioned as an attack is made against a person who is supposed to be the pillar and the fountain of justice, Your Honor. And the delicate nature that therefore comes from that intricacy is that the notion of justice, Your Honor, is rooted in the public having confidence and trust in this institution called the courts, and trust in this institution known as the judiciary, in the fair and just determination of these things. Therefore, Your Honor, when we come to balance the intricacy, and the delicate nature of these applications, we are told that it is the paramount importance to ensure that the confidence, that is the delicate ambit of this application, the confidence of the public is not eroded by the refusal of judges or judicial officers in this matter. To disqualify themselves whenever an application such as the one before you is made, Your Honor. And this balance, Your Honor, is not one that I have fashioned myself, but these are the words of Justice Wasame, as he then was, in the case of Alliance Media Kenya Limited. Alliance Media Kenya Limited.
My first allegation issue, Your Honor, I totally disagree with the court. Respectively, I agreed with the 30 working days.
No, it was not you. Sorry. When the council was, I think it was something there, he said that in the other application, the one inside the case, the miscellaneous case number E077 of 2020. This one is E081. So in that file, it was some 4 respondents were brought before me on Monday this week. And the prosecution made an application that I demanded for that working days to enable the investigation to be concluded. When every one of them stood up to respond, one by one, they say, we will not object. It can be demanded for that working days. But now for me, when I was making a decision, I decided not that working days. Because that working days means 45 days. So I decided to give that current attention. It was not you question, it is the other opportunity to make a decision. So you understand. The ones who are already now as we speak, the ones who are already now in custody and their case is already being investigated and they are coming back to the It was not you whom I think you agree. No, it is those are the four. There was a thing somebody Ali Juma and another set of questions. That's clear. It was not, it was those that I was working. So for you, you are yet to say whether you agree or don't, or whether you agree with that assumption or not. But we are yet to get there. Because at this point, the prosecutors there wanted to prosecute that application. Now that they're seeking that to be remanded for whatever number of days they are saying. But before they could argue, the advocate for fact and respondent and said, no, I should not do that. I'm biased. So I should walk away and then let somebody else do it. So that is the issue now you should address the court. You feel I should hear this case, or do you agree with first respondent that I am biased and that I should stop handling this case and hand it over to another judicial officer?
I totally agree with that.
That? What do you agree with that?
It's not that it's
What are the reasons?
the ruling that has been delivered. Not
So the the one that's saying this protest restriction. Anything else on that? Any story? You're following the distance and the elements? So you're following where we are now? You're listening. What are you? What is you want? Sawa sawa. Endelea. Kulingana na wewe maoni yako ni gani? Hatujafika kuongea upande wa mashtaka, wanaenda makosa ama upande wa mwenye and wa investigator. So unajua leo ilikuwa nimekuli kama iko na hiyo jukumu sheria. Na nikasema kweli iko na hiyo jukumu, ina uwezo wa kuendeleza. Sasa tungeendelea na maombi yao ya ile application. Ninasema unafaa mweko custody siku ndio hayo amaliza uchunguzi. Lakini kabla tuende kwa hiyo application, mawakili wa first respondent Ebelo wamesema hapana. Mimi mwenyewe sifai nijitolee kwa hii kesi hakimu mwingine asisi. Wanasema office bias inapendelea upande mmoja, inaegemea upande mmoja. So wanasema yeye haoni kama nitatenda hapa. Tena nasema kuna watu wengine walioto hapo imani kwa hiyo nitasema waweka ndani. So naona ni kama nilisema wengine wataweka ndani, hata nyinyi nitasema hivyo. So ndio tunaongea sasa, ile mambo iko kwa desk sasa hivi ni nini ndio. Ndio sasa kulingana na vile uamuzi nitaamka, naweza sema hapana tuendelee. Ama naweza sema najiondoa nyingine. Hapo ndipo sasa tutaingia kwa application ya siku. Sasa hii mambo ya mimi kujiondoa tunasema tunakubaliana na wao ama wao iko sawa tu. Maoni yako kama
No, we did not hear his response.
Amesema koti endelee.
Okay.
159 that deals with judicial authority. Where the Constitution says the judicial authority is deprived from the people and is exercised by the courts and tribunals established under this Constitution. It then goes on to say that judicial authority shall be guided by the principles, the following principles, such as justice shall be done to all, irrespective of status. Justice shall not be delayed. Justice shall not be delayed. Irrespective of status. Justice shall not be delayed. And the purpose and principles of this Constitution shall be protected and promoted by judicial authorities. Article 160 deals with the independence of the judiciary. Article 160 deals with the independence of the judiciary. and imputes that a person exercising judicial authority shall not be subject to control or direction by any person or separate authority. My lady, I bring the Constitution up because of the allegations that have been brought up in court today by the first and second respondents. They have called for the recusal of this court, alleging bias, this bias has not been articulated or documented by way of affidavit or application. Rendering the same as mere allegation without any footing. Your Honor, an applicant who makes such a serious application as of recusal of a judicial officer bears the burden of proof which is a high burden and must demonstrate the allegations raised in an articulate manner, bearing in mind the impact of the allegations raised to the court process and the judiciary in whole. Your Honor, the Judicial Service Act, I'm sorry, I lost the section. I think it's 3.